Hello, we are here for oral argument in CC 21-0002, Arizona Public Service Company versus Arizona Corporation Commission. You are probably familiar with our process that we record and live stream, but as you stand up to argue, please announce for yourself your name and the party that you're representing. We have you down for a maximum of 20 minutes per side. You're not required to use that all. I suspect we probably will today use all of that time, but if you'd like to reserve some for rebuttal, keep track of your time on the podium. We have read the extensive briefing, attempted to study the very extensive record. We discussed the case in conference this morning, and we're ready to hear from you. So with that.
Thank you, Your Honor, and may it please the Court. Thomas Hungar for Appellant Arizona Public Service Company. With me at council table is my partner, Matthew Rosen. I'd like to reserve 5 minutes for rebuttal. The Commission's partial disallowance of the SCR's investment is unlawful, unsupported by the record, and arbitrary and capricious, and should be reversed with directions to allow the full amount of the investment. Time permitting, I'd also like to address the unlawful 20 basis point reduction in return on equity. First, the SCR's disallowance is unlawful because it's based on impermissible hindsight. As the Commission's decision itself expressly admits at footnote 189, the disallowance, quote, is based on the early 2031 retirement of the SCRs, close quote.
Is that the amount of the disallowance, or is that the disallowance?
Well, what they said is the disallowance in that footnote, and they also say, of course, in the text that the disallowance is based on, quote unquote, planning imprudence.
So I have a hard. So depending on which mood I'm in at the time, when I look at it, I either think, wow, this is impermissible backward looking, or they found it was imprudent at the time, the entire investment, but then cut you a break and allowed you to recover half of it. Which is the correct reading of the ACC's decision?
Well, I think the fact that the ACC's decision is ambiguous and unclear is itself a problem and shows a flaw in their reasoning as a matter of administrative law, because one thing that courts need from agencies is clear explanations of their rationales. But either way you look at it, it's flawed. With respect to the hindsight, and again, it's not just that footnote. I mean, that footnote makes clear that the disallowance is based on...
Well, their brief, as you point out, says it was to reflect the shortening of the time period.
Exactly.
Obviously a backward-looking decision.
Yes, Your Honor. So, and that is unquestionably a violation of their own regulation, which they are bound by, and they can't just say, well, we can proceed in some other manner and ignore the regulation. That's contrary to fundamental principles of administrative law and due process. I mean,
but you acknowledge they say other things in there about ACC or APS. I'll mix up these acronyms all day, sorry. But that APS knew or should have known at the time that it made the decision to invest in the SCRs.
They do say that, Your Honor, but what's the evidence?
So which one do I rely on?
Well, in this case, I think you don't have to. I mean, one thing a court can say when it's unclear what an agency's rationale is send it back and make it clear. But here you don't need to, because the hindsight rationale is clearly one part of the rationale for the decision, and that's unquestionably unlawful. And it's not just the footnote about the 2020 decision to shorten the time frame during which the plan will operate. Because if you look at the list of evidence, they make that statement that Your Honor referred to about how the company should have known at the time. And then they cite this long list of evidence that purportedly supports that determination, separate and apart from the 2020 decision about the retirement of the plant. But if you look at that evidence, it's also talking about, well, look, well, here's pricing through 2019, and here's going forward from today. We can look at prices on, solar power and batteries and so forth are coming down. That's all. That also is all hindsight. So again,
Counsel, does there have to be some level of hindsight looking back? I mean, the very nature of the rule says at the time of the investment.
Yes, Your
So
Honor.
to evaluate that, you would, by necessity, have to look at history in some fashion to see what happened at the time of the investment. Now, with putting aside when that occurred, we'll talk about that in a minute, but how does one evaluate what happened at the time of the investment without looking backwards?
Well, the inquiry can be conducted after the fact, but the question that the commission is supposed to be asking is, based on the relevant point in time, which they never specified, but let's say for sake of argument, it's August of 2015 when the companies they signed the contract.
And is that APS's position? That's when that should be the investment at the time of the investment, August?
Well, I mean, in our view, 2014, when the commission determined it was prudent to acquire the plant, which entailed the purchase of the SCRs and the expenditure on the SCRs, and the commission itself in 2014 analyzed the cost of the SCRs' expected investment and determined that it was prudent to proceed. In our view, that was a determination that based on the information available at the time, it was prudent to proceed with this plan to spend $365 million on the SCRs. That didn't mean that if they then installed, gold-plated faucets, that the prudency of that couldn't be examined, but it did mean that the prudency of the decision had been established. But even for the sake of argument, if 2015 is the relevant time period when they actually signed the contract, the fact remains you can't consider evidence about what prices are in 2016, 17, 18, and 19 and what they're projected to be as of today going into the future and say, well, aha, we know that batteries are cheaper than they used to be and solar power is cheaper than it used to be, and therefore the decision in 2015 was imprudent. That is an impermissible hindsight. And with respect to Judge Morse, your question about sort of the other part of the analysis, even putting aside the impermissible reliance on hindsight, which itself, because that's an integral aspect of the commission's reasoning, you can't say we know what the commission would have done if it hadn't relied on hindsight, because hindsight is all throughout its analysis. So that alone means the court can't substitute its judgment for the commission and say, well, maybe there's something else they could have said, and so we're going to uphold it. You need to send it back for the commission to do its job under a correct understanding of the law.
So that would be our remedy, if we agree with you, and I'm definitely not saying that we do yet. Our remedy would be just to let the commission go back and make new findings based upon the existing record, do a whole new rate hearing. What do we do? If
the only error in the analysis that the court found was the impermissible reliance on hindsight, the proper remedy would be to remand, vacate the disallowance, send it back to the commission with directions to redetermine the prudence issue based on a proper understanding of the law, not considering hindsight evidence. However, there's
on the existing record?
We believe so, yes. But beyond that, there's a more fundamental error, which goes to the other half of your question. Even putting aside,
I don't remember what the second half of my question was.
the sort of the finding that says we find as of the time, without saying quite, they say, I think essentially before they started building it, they should have known that it was imprudent. And that finding is completely lacking in evidentiary support. In fact, the commission relies primarily on the Sierra Club. The Sierra Club's witness admitted, and this is at pages 3083 and 3087 to 89 of the evidentiary hearing transcript in tab B31, and the Sierra Club admits this in their briefing too at volume 10, page 97 of the appendix. The Sierra Club did not do an analysis, an analysis as of 2015 or indeed as of any time during the construction of the SCRs that said, here we can identify an alternative portfolio that could have been constructed by 2018, which it had to be, because if you're not doing the SCRs, you're going to lose 1,000 megawatts of capacity as of 2018, and the lights are going to go out if you don't replace it. So they had to be able to identify an alternative portfolio of generation capacity that could have been installed within that time frame and that would have reliably served the needs of the Arizona ratepayers.
Did they identify an exit strategy? I mean, how you could have exited the contract with the partners?
There's no evidence about how much it would have cost to get out of the contract. Whether the other companies, I mean, this is not just Arizona Power, right? There's several other co-owners who all signed the contract. There's no evidence about what it would have cost to get out of that contract, whether they could have gotten out of it, whether the other companies would have agreed. I mean, to do a prudency analysis and say, we're going to overcome the, I'm sorry.
No.
Remember, we start with the regulation which says prudence is presumed. The presumption governs unless there's clear and convincing evidence of imprudence. So the commission, in its decision, if it's going to do a proper prudence analysis, needs to, and find imprudence, it needs to point to the evidence in the record that says, here's an alternative they could have done at the time and that they should have known about based on information that was available at the time that would have reliably served the needs at a lesser cost. They did none of that.
Originally, I read your briefing in the record and was found compelling the argument that since the SCRs were at least impliedly contemplated, if not explicitly contemplated in the original decisions, that there was a implied prudence decision originally. But then I read the decisions and they say, and I'm not going to quote from them, but the first one says, by the way, we're not deciding that any non-fuel expenses are prudent. And then later decisions explicitly reserve prudence decisions on the portion of the SCR investment. So what is your best argument that that original decision locked in prudence finding from the ACC at that point?
Well, so there are multiple decisions, and our argument on that point relies on the 2014 decision, not
Right.
the 2012 decision, right? The 2014 decision, the question in front of the commission was, is it prudent for the company to spend all this money and purchase this capacity at Four Corners Units 4 and 5? They were spending over $200 million to buy the capacity, and then they were going to spend additional money, $365 million for the SCRs, all of which was necessary to get the benefits of that additional capacity, because otherwise you'd spend hundreds of millions of dollars and then shut the thing down in
But the
in a few
commission
years.
specifically said, nothing in this decision shall be construed in any way to limit this commission's authority to review the entirety of the acquisition, make any disallowances therefore due to, or thereof due to imprudence. So didn't they reserve
I
that?
believe I think that's the 2012 decision, Your Honor.
Right.
If I'm not-
And
but
then-
I'm talking about the 2014 decision.
Okay, and then the 2014, they say, it approved the authorization or authorized the acquisition, but then, quote, deferred for possible later recovery all non-fuel costs owning and operating and maintaining Four Corners, which seems to be reserving the,
I may be mistaken,
Issue.
but I think that's the 2012 decision also. The
that's
2012
the second decision, so maybe I've got the year wrong, but that's the second decision. That's 74876.
74876. 74876, that's the 2014 decision. Well, I mean, I'm not sure where exactly in the decision that point is made, but the question, what the commission clearly did conclude in 2014 is that the investment in the units 4 and 5 was prudent and could be included in rate base. And our point is, while that's not a determination that the actual final installation cost of SCRs is prudent, because of course we don't know how much they're going to spend. They think they're going to spend $365 million, but that hasn't happened yet. It is a determination that based on the information available as of 2014, there is benefit to ratepayers. It's a good, prudent decision to proceed to spend this money, knowing that part of the money we are committing to and planning to spend and factoring into our economic analysis is the cost of the SCRs. At pages 76 and 80 of volume 11, that's the 2014 decision, that they specifically talk about the fact that the SCR's capital costs are part of the costs they're factoring into the analysis. Because remember, this was heavily litigated. They had a whole trial in front of an ALJ. The Sierra Club was there arguing, oh, your gas price projections are wrong, your capital costs aren't high enough, you know, it's going to be a lot more, it's going to cost a lot more to do what you're saying needs to be done, which included the SCRs. This is all in the record. The commission knew about the cost of the SCRs. They talk about the SCRs in their decision, and they factored all of that in, and they said there's a net present value. Staff found over $300 million in benefit from going with the Unit 4 and 5 project, which included the cost of the SCRs. They said there's a net present value. So for the commission to turn around now and say, well, as of 2014, it was beneficial and prudent to spend all this money, which we knew included the cost of the SCRs. They said that was beneficial and prudent if it was going to cost $365 million. Then for them to turn around and say, oh, but in 2015, the company should have known it's imprudent without any evidence of any analysis that changes the results of the previous analysis, right? They did an analysis in 2014 to determine, you know, how much money is this going to cost and is it beneficial compared to alternatives? And the commission said, yes, it is beneficial. They didn't do an analysis in this decision saying, here are all the reasons why that conclusion had changed as of 2015 and the company should have known it. And without such an analysis, you can't overcome the presumption of prudence. There's a further independent reason from these points why the SCR's disallowance is unlawful, which is that it is completely inconsistent with the commission's treatment of Tucson Electric, which also owns a share of the plant and the SCRs and was allowed to include all of those in rate base, even though the Sierra Club in that case, as here, said, oh no, they engaged in planning imprudence. They failed to reanalyze the prudence of continuing to operate Three Corners with all these costs. So you should say that it's imprudent. Then the commission said, no, that's not how we do prudence. We look at prudence at the time of the investment. I'm
glad you raised that because it's mainly a question I want to ask ACC. But in your brief, you raised this issue, the inconsistency, the arbitrariness of the comparison. And their response is that the decisions are not inconsistent because in the TEP case, the commission found Sierra Club had not presented any factual legal support. What was the different evidence that was presented between the two hearings? Or is that part of our record?
That is not part of the record, but what is in the appendix is the is the TEP decision, and in that decision, they make clear that the Sierra Club's argument was the company has never done never did a subsequent reanalysis of prudency to determine, even if it was prudent initially, is it prudent to keep going with the Four Corners plant, given all these costs, of course, including the SCR's costs, which the Commission allowed them to include in the rate base. That sort of imprudent planning analysis argument that the Commission rejected in Tucson Electric is the very argument, of course, that they accepted in our case without any acknowledgement of the inconsistency or any explanation of why it makes sense to treat two similarly situated companies differently. That's the definition of arbitrary and capriciousness.
I know you want to reserve some time, but I want to ask you one quick question. Am I right, you guys are not challenging whether prudence is allowed as a consideration?
No, we're not challenging that. I mean, the regulations make that clear, and that's
because when doing the research for this, I read Arizona Water Co. From back in 1959, where the Supreme Court says it's unconstitutional to use prudent investment theory in determining fair market value. So why isn't that a consideration here?
Yeah, I remember reading that and being a little confused by that statement. But I mean, I think the short answer is we haven't challenged that, and it is. So
it's not
settled.
an issue. I don't need to worry about Arizona Water Co. At least that part of it.
Right.
I know you cite it for other purposes.
Yes.
Okay.
Yes, correct.
And then the second question, I would like you to talk about the 2% or 0.2%.
Yes. Yes. So in our view, that is unconstitutional and an impermissible penalty. So recall that the Commission first said.
Let me kind of back to the first question I asked. So one way to look at it is 8.9 was the appropriate rate and 2% is a penalty. Or one way to look at it is they found a range, and one point of that range is 8.9, but because your customer service was subpar or lacking, we're setting it at 8.7. How do I decide what's a penalty versus what's an appropriate rate? And am I the right person to make that decision?
Well, I think you read the order and determine the Commission's reasoning, and the Commission's reasoning in this case was they adopted RUCO's 8.9% rate as the cost of equity. So their conclusion, fairly read, is when you apply the constitutional standard, what rate does the market demand for comparable investments, they concluded 8.9%, which is based on RUCO's 8.9% number. And then they said...
But didn't RUCO have a range? Didn't they propose a range?
Well, they may have proposed a range, but the Commission said, I think 8.9% I think is where they settled. They said you could have a range. 8.9% is where they settled, and the Commission adopted RUCO's calculated cost of equity of 8.9%. That's at pages 15 and 22 of Volume 5 of the appendix. And given that, the constitutional rate of return, I mean, we have arguments about why we think it should be higher, but putting that aside, if 8.9% is what the Constitution demands, you can't then drop below that to punish for bad service. And they didn't, it's not like they did an economic analysis, they did a penalty analysis. They said, well, why did they impose the 20 basis point reduction? And the decision says it's because of what RUCO's witness said, which is we need to send a message to the company. That's a penalty analysis.
So is it unconstitutional for them to consider, I don't know how to phrase this, non-economic considerations in what they determine the rate? In other words, can they not factor in customer service, or is it just the way they factor?
The Commission has many authorities that allow it to address concerns about customer service. The penalty authority being only one of others, right? They've got their permissive authority. They can do all sorts of things and order all sorts of standards to be followed and adhered to, and take steps if they're not adhered to. But that's not part of the rate-making function.
So it's unconstitutional to consider customer service in rate-making?
Yes, certainly it's unconstitutional to do it in the way they did it here, but we would say it's not permissible at all. And we cite a number of cases from other jurisdictions, Ohio, Kentucky, Florida, that I think are very instructive. They have similar regimes to here, and they say rate-making is about the economic analysis, and poor customer service sanctions are a separate inquiry. And if you allow so the Kentucky case in particular, like the Supreme Court of Arizona in Johnson Utilities, says the rate-making power is to be strictly construed, and we shouldn't therefore allow the Commission to cram into the rate-making function all of these other issues, like, for instance, poor customer service. In fact, permitting the Commission to do what it did here would eviscerate the Constitution's protections and limitations on the penalty power. The Constitution sets up precise limitations, procedural and substantive, on the Commission's power to impose penalties. But if the Commission can just say, oh, pish posh, we don't need to worry about that because we can just do whatever we want through the rate-making function, those limitations go out the window. So for all those reasons, we ask that the decision be overturned and that remanded with directions to recalculate the cost of equity and fair value increment returns, and to award the full value of the SCR's investment. Thank you.
Thank you. Do you want to go ahead and add it?
Yeah, why don't you?
We're going to go ahead and add 5 minutes to both sides, please. So if you'll give the bailiff a moment to set the clocks appropriately.
Can you guys see the clock out there? It's kind of exciting to watch it.
There it goes.
See a whole bunch of people like craning.
Good morning. My name is Robin Mitchell, and I'm appearing on behalf of the Arizona Corporation Commission and its 5 elected members. I would like to reserve 5 minutes of the time to allow for a response by Sierra Club and RUCO.
Is that 5 minutes each of them or 5 minutes total?
They probably would want 5 minutes each, but I was thinking 5 minutes total, so they would split their time, so like 2.5 minutes.
Okay.
Despite the hyperbole and the over-the-top rhetoric of APS, there are really only 3 issues for this court to decide. Is there substantial evidence to support the Commission's decision to disallow $215 million in rate base for the SCR project? Is there substantial evidence to support the Commission's award of an 8.9 ROE, which is return on equity, reduced by 20 basis points for poor customer service? And is there substantial evidence to support a 0.15 return on the fair value increment?
Counsel, just one clarification on the first issue you identified about substantial evidence to support the disallowance. If we were to agree with APS that the Commission improperly applied or improperly interpreted the prudence evaluation, do we get to substantial evidence, or isn't that a legal determination that we would then send back for a reevaluation of the evidence?
Judge Perkins, I think that's a legal analysis. Substantial evidence is the standard of proof.
I guess what I'm getting at is, maybe to clarify, the first issue is sort of in 2 parts. The first part being that legal, whether or not we agree with APS on the legal challenge, and that only thereafter would we get to whether there's substantial evidence in the record.
In order to overturn a Commission decision, it has to be shown that there was not substantial evidence to support that decision.
Or are you going to go or it was arbitrary or unlawful?
I was getting there.
Okay.
I was getting there. Or that the decision was arbitrary, capricious or unlawful. And so that requires a look at the record to determine whether there was evidence enough to support the Commission's decision. If this court finds that there was substantial evidence, then I think the inquiry is done and the Commission's decision is affirmed. And I hope I'm answering your question.
But wouldn't we want to make sure, don't we need to make sure that the Commission appropriately applied the law first, before I think it's following up on Judge Perkins' question, don't we need to decide, did the Commission properly apply the prudence regulation in this case as a threshold matter? And did it according to its plain language? And then also, did the commission apply the proper law when it comes to the alleged penalty on the 20 basis points?
Judge Brown, I think your analysis is correct. It is within this court's purview to decide the constitutionality of the actions of the commission. Some people think that the commission's power is boundless, but it is not. And it is for this court to decide whether the commission applied the law appropriately. And of course, our answer is yes, we did. And there's substantial evidence to support that. APS said a number of things during their argument that I just feel the need to clear up. The first thing is they continually argue that the commission decided prudency of the SCR investments. In their opening brief, they said it was the acquisition decision. By the reply brief, it became the decision that allowed the acquisition into rate base. That is simply untrue. The commission reserved the right to review the prudency of not only the acquisition, but the SCR project. APS seems to argue that because we told you how much it was going to cost, that automatically means prudency. But the prudency rule says that we get to determine, prudency is determined at the time of the investment. At 2014, they had not made an investment in the SCRs. So how could the commission have determined prudency prior to an investment? If the rule says the investment, prudency is determined at the time the investment is made. There are repeated places in several commission decisions that say we reserve the right to review this for prudency. You only get to 2016 decision from the 2016 rate case where the commission said, okay, we're going to make provision for this to be determined in APS's next rate case, which is what happened. And so I just need to dispel that fallacy that prudency was predetermined before the investment was even made.
Okay, so when was the investment made? What's the commission's position on when it was made?
The commission's position would be 2018 when they completed the project. And then they came to the commission. There was a case that was before the commission to talk about prudency, but it went to a hearing. There was a recommended opinion in order, but it was never voted on by the commission.
Are you aware of any authority that would say that an investment is made when a project is completed versus when a project is initiated?
Judge Brown, the problem with that is you could say at the beginning it is prudent. That would open the door for utilities to then maybe do runaway cost.
Well, I'm not suggesting you have to make a determination. I think opposing counsel suggested, the questions about prudency can come months, years down the road. It's just the question is, what are we looking at? What is the snapshot we're looking at? What kind of picture of what events were occurring at the time when we say based on or at the time of the investment, which is the language of the regulation, if I'm quoting it correctly, at the time of the investment. That's what I'm really trying to drill down here is, yes. What did the commission mean when they adopted that regulation?
So what normally happens, Judge Brown, in big rate cases where there are a lot of plant put into service, the commission doesn't have a prudency hearing prior to the rate case. What was different here for APS and the reason they had to come in for the acquisition is that they were under a self-build moratorium, which means they could not build additional generation or they could not purchase additional generation without seeking a waiver for the commission. So in typical rate cases, you come in, you bring all your schedules, you say at the time, we built we installed a gas turbine. Now we are seeking recovery. maybe they installed that gas turbine during the test year. We don't say prudency then. We say prudency if it is an issue at all, because prudency is a presumption. We say that in the context of a rate case. That's why the commission could not have determined prudency in 2011, in 2014, in 2016.
Understood, but aren't you looking, when you do determine prudency, aren't you looking at events that occurred leading up to the decision-making process? I know when you use the gas turbine example, the company has to decide at some point, do we go forward? Do we build a gas turbine? Is it going to be worth it? Is it going to be worth it to the users? To the public? Is it going to be worth it to our company? Balancing all the factors, they have to do all these considerations.
Right.
So when you do the prudency, aren't you looking to see at the time of that decision, was it reasonable? Was it reasonable and prudent at the time of the decision?
You mean at the initial decision to install the turbine?
To look back and see what those events were going on at the time, to see, as opposed to saying, oh, you decided to close this plant early. That's a factor we can now consider.
Yes.
That is where I'm having a real hard time knowing. Maybe you can address that and would help me, because I don't understand how that's even relevant, going from 38 years down to 31 for the purposes of prudency.
I can address that. The reason why it was important and that it played into the Commission's prudency determination was that in APS's application, they assumed a 2038 closure. In APS's integrated resource plans, they considered a 2038 closure. I think when they announced that they were closing in 2031, that changes the whole dynamic of what they're seeking. And APS continued to seek recovery through 2038, knowing that they were going to close that plant in 2031. I don't know that it's that much of a prudency determination as much as the inherent power of the Commission to protect ratepayers from an investment that may no longer be prudent.
Let me ask you this, could the Commission have taken that factor into it in setting the rate on the return on equity and said, hey, you know what, you were being a little disingenuous here about not telling us your plans for closing, or you should have been, telling us about your plans, and therefore we're going to dock you down not 20 basis points, but we're going 200 basis points. Could the Commission have done that?
Well, according to APS, we could not, because we can only consider, the economic factors. But I believe that can be considered in the determination of an ROE. If you what regulation does? Regulation says, company, if you manage efficiently and if your costs are in line, then you are allowed the opportunity for a fair return on your property devoted to public service. Regulation, in a sense, at least economically, mimics competition because they're a monopoly, but we also have a duty to protect, ratepayers from runaway cost. And so that is really the function of an ROE. If you look in a competitive market, if you had a company who had bad customer service, who had a consent order with the Consumer Fraud Division of the AG, the market would reflect that for that company. This is what the Commission does when it looks at ROE.
Right, I agree with you completely. Regulation is supposed to rein them in, but they seem to be drawing the distinction, and what I'm asking you to tell me is what authority does have for rate making to fill that regulatory requirement as to customer service?
That is inherent in the authority of the Commission to protect its ratepayers. So what the Commission has to do is not only be fair to the company the commission also has to protect the ratepayers because we're the ones that are sort of standing in the gap to make sure that consumers get safe and reliable service and they pay the cost that is necessary.
What Judge Morse is getting at is if we agree that that is the proper role of the Corporation Commission, what is your authority that the exercise of that role occurs within the rate-making function as opposed to in its authorized, penalty function or
other enforcement
separate
measures
enforcement mechanisms?
I think it's because it is just a rate-making principle to mimic competition. Secondly, the Commission's powers are quite broad under Article 15, Section 3. And what happens there is that the courts have interpreted that to mean, what I keep saying, and maybe I'm not understanding the question, but we have a role to protect ratepayers too. And so that tension between making sure the company has access to capital, make sure that their financial integrity is kept, make sure they can still provide service, we have that tension that we have to make sure we're fair to the company, but we also have a responsibility to the ratepayers to make sure that, they don't have to pay 1 cent more than they need to pay. And so when you look at the ROE, I'm just going to say mimics competition, the Commission, I think in its range of discretion that it has in rate making, has the ability to factor that in. The market would factor that in if you had poor customer service, if you put customers on the wrong rate plan and you were telling them that this was supposed to help them and it did not help them. The Commission has to have some way to address it. Now, could they have addressed it with a penalty? I suppose they could have the penalty function under the Constitution, under Article 15. I think they could have, but they chose this way in the context of a rate case.
So what is the 2% reduction then? Is it a penalty?
I would say that the 2% reduction would be reflective of what the market would do if APS were not regulated.
Okay. I want to go back to prudence a little bit, which I don't know if we ever left. It's all kind of interrelated.
It is.
Do you agree or disagree, and I'm not trying to lead you, that the prudence, your regulation requires prudence to be measured at the time of the investment?
Right.
Okay. In your brief, you say the Commission ordered the $215 million rate-based disallowance to account for APS's unilateral actions taken which significantly shorten the life of Four Corners. That sounds backward-looking to me. Is that a decision that was made at the time of the investment?
I think, Your Honor, that APS lacked candor to the tribunal about its intentions regarding Four Corners.
Right, and the decision cited that some of the failure to include gas price estimates and I think alternative energy source
But even
estimates.
to address your point about the early closure, APS knew that was a possibility because they had been discussing that possibility with the other owners of Four Corners. In fact, Public Service New Mexico, which is an owner, was going to file to abandon its position in Four Corners. And as part of that owner's discussion was, can we close early? Can we close in 2031? At that time, then they announced that they're going to close, and the Commission learned about it in a press release. And so then that had to become part of the hearing because there was concern that your analysis for your rate increase talked about 2038.
That was after the SCRs already were underway, right?
They were already installed? Yes,
or at least they had signed the contracts to begin the construction of it.
I believe they're already installed.
They were installed at the time of the hearing in this matter.
Okay.
I think they completed the installation in 2018.
Isn't that backward looking then?
I don't think that it is because what I think about that the Commission's actions regarding the disallowance is that I don't think the commission's hands can be tied when they learn factors after the case, they learn factors that would negatively impact the ratepayers. Because what would have happened, let's say, that, just for the sake of argument, that the commission did not talk about the early closure and the seasonal operation of Four Corners. Excuse me, I'm getting dry throat. You know, I think then the commission would make the disallowance based on the evidence that was presented. The commission would then, have protected ratepayers, but the situation changed because of APS's lack of candor to the commission, because that would impact the rates that they were seeking. If we include 2038, when we know as a commission that it's 2031, I think we would have abdicated our responsibility to protect ratepayers who are going to bear the cost of all of this and give them recovery through 2038 when nothing was going to happen after 2031. And so I think the commission took all of that into consideration and made the decision that it did. This was not a total disallowance. The commission recognized that there was some used and usefulness of that plant. That's why it wasn't a total disallowance. But the commission felt that the lack of candor and the impact, which would have been, rates would have been higher for those ratepayers, I believe it's inherent in their rate-making authority to go ahead and take those factors into consideration.
Can we stop the clock for just a second? Can we have one more minute? Because I would like to ask one more question. I don't want to cut into their time. So 1 more minute for both sides. We get to watch the clocks again. Close enough. All right. My last question to you then, we got 56 seconds. Explain the APS versus TEP distinction, because your brief, all you say is, well, they didn't present sufficient evidence, but doesn't there need to be, you have two similarly situated companies presenting the same case, and you gave one of them the full thing, the full enchilada, and the other one you cut the enchilada in half. So what do we make of that?
Well, Your Honor, what I make of that is that each case stands on its own and its own presentation of evidence by the parties in that case. And the ALJ that heard the case felt that there was not sufficient evidence.
Well, the ALJ in your case found the same thing, or in this case, but you guys overrode the decision, right?
Yes.
Okay.
Well, not exactly. She denied full recovery. The commission, wanted to acknowledge that those units were helpful during the 2020 heat storm, and that's why it didn't allow for full disallowance. They allowed for partial disallowance. One other thing I wanted to address. I'm done. I'm cutting into their time.
Yeah.
Okay. I tell you what. I won't. It's probably been our brief anyway. And thank you for your time. And I'm going to let Sierra Club.
Greetings, members of the court. My name is Andy Kovesich, for the record, arguing on behalf of the Residential Utility Consumer Office as intervener, not Sierra Club. Ms. Mitchell, we could talk about this all day. I want to take 2 minutes and just focus on the standard of review in this case, because I think it makes the court's job simpler in quite a complicated case. There's a stringent standard of review in this matter because of what the Arizona Constitution says. And it says that the Arizona Corporation Commission is the exclusive body to set rates and regulate public service corporations. That's how the framers wanted it. In fact, the framers diverted that task from this court. And I think after looking at a 400-page decision, you may be thankful that they did that you don't have to deal with rate making. But with that said, that doesn't mean that the commission's power is unfettered, that they can do whatever they want. And to borrow language from Judge Brown, that doesn't mean that this court is simply a rubber stamp on everything the commission does. And so that's where the standard of review comes into play. And so to that end, this court should disturb the decision only if it was arbitrary, unlawful, or unsupported by substantial evidence. But beyond that, APS has to prove that to the court, and they have to prove that to the court clearly and convincingly. And based on those parameters, when viewing the decision, we think it should be affirmed.
Let me ask you a subpart of that then. I agree 100%. I was in the losing side on Sun City, where I said extreme deference. So it's something less than extreme deference, but it's still deference on factual issues. But don't I read Sun City as saying that we reviewed de novo legal issues?
Yes, and
So we don't defer to the APS's interpretation of the regulation,
I will
or
tell you,
ACC's interpretation of the regulation.
I will tell you, Your Honor, that opinion on that point has tortured me since the day it came out, because on one hand it
But the
says,
people upstairs, I have to follow them. So you'll agree that that's what Sun City says?
yes, my view is it's always this court's job to tell us what the law is and to interpret the law. And
So there's no Chevron deference afforded to their interpretation.
correct.
Thank you.
I also want to touch on a question that the court raised related to rate making and whether you can consider consumer interests. I think you can. If you look at the Hope opinion, it says that you need to balance both investor interests and consumer interests. And it's the
Does
commission.
it say that in rate making? Is that in the rate making code?
In discussing just and reasonable rates. And so if you look at the Arizona Constitution, and it requires the commission to set just and reasonable rates, the word just should mean something, and so should the word reasonable. So I would interpret the word just to say you have to take into account the consumer's situation. And is it fair? Is it just to the consumer to have to pay a certain rate when they're suffering from all these customer service issues? The point at the end of the day is that the commission gets to decide that, and they did so, and that's how they arrived at the 8.7 figure. And there's plenty of evidence in the record to support that. And I'll close with this. Speaking of Hope, I think the language in there and the guidance from the United States Supreme Court is helpful here. And at page 602 of that opinion, the High Court encourages you to view the Commission's order in its entirety and focus on the result reached, which is controlling, and not necessarily the method that was employed. And those that challenge Commission decisions like APS carry a heavy burden. And if the total effect of the rate order is just and reasonable, then the judicial inquiry is, quote, at an end. And so for those reasons, we'd ask the court to affirm the decision. Thank you.
May it please the court, Rose Monahan on behalf of CR Club. There have been a lot of issues raised today on the SCRs, and I would like to focus on the evidence that was available at the time that APS made its investment decision. The investment decision on the SCRs was made between 2015 and 2018, so it was relevant for the Commission to evaluate all evidence.
Is that true? I thought that they had locked in, they signed the contracts that was going on at 2015. They were pretty much, the price was fixed at that point. Is that not accurate?
APS did sign a construction contract in 2015, but that contract was not the end of the inquiry. A prudent utility continues to evaluate the economics and stay abreast of whether it makes sense to continue on in the project.
But if it's measured when it's made, don't we usually say you've spent money when you signed the contract?
Not all of the money had been spent in 2015. That was just the signing of the contract. The construction was carried out over several years and was not completed on one unit until 2017 and the other unit until 2018.
Is there any evidence in the record that tells us what the cost would have been of breaking that contract? Because it seems to be what you're saying is they weren't locked in, or to the extent they were locked in, it might have been more prudent for them to jump out. Could APS have jumped out? Is there evidence in the record that tells us that they could have withdrawn from the contract and just stopped paying on it?
No, Your Honor, there is no evidence on that in the record. Sierra Club's argument throughout the case was that APS had failed to do that very analysis. In fact, they failed to do an analysis on whether it made sense to move forward with the SCRs after perhaps 2014, perhaps as early as 2012. And we know that because in 2012, they did an analysis that showed if there was low gas prices.
Thank you, counsel, for your answer.
Thank you.
Excuse me. Thank you, Your Honor. A few brief points. First, just following up on the Sierra Club's point and the fact that there's nothing in the record on the cost of breaching the contract, which is what they suggest should have happened. That just proves the point, and their argument that the obligation was on APS to essentially prove prudence and reprove it every time simply confirms the fundamental violation of the regulation that we're dealing with here, because the regulation puts the burden on the party seeking to prove imprudence. We presume prudence. If someone wants to prove imprudence, they need to come up with evidence that says, look, here's a better way, based on the evidence at the time, that you could have done this. And here's what it would have cost to do it, by breaching the contract, by miraculously finding new capacity within 2.5 years to replace 1,000 megawatts. I mean, none of that could have been done, in our view, but certainly they had the burden of proving it, and they didn't prove it.
What about, she also argued, though, that the contract, you could have looked at the big picture, and APS should have never entered the contract. I mean, it should have never gone down this road. I mean, she said the evidence was there on the table that it was a bad decision to go forward with the SCRs.
She says that, but she doesn't cite any evidence because none is there. And again, at 3083 and 3087 to 89, their witness, Sierra Club's witness, admits, I didn't do that analysis. He says it was APS's burden to do that analysis and redo it, but the presumption works the other way. And remember, the Commission had done that analysis in 2014. Whether you want to call what they determined a prudency determination or not with respect to the SCRs, it is undisputed, and no one that you heard from today denied, that when the Commission determined that it was prudent to invest in Units 4 and 5 and acquire that plant and keep it operating to provide power for the people of Arizona, part of that analysis, part of that financial analysis that said, yes, there is a financial benefit that makes sense for this to go forward, necessarily included the costs of the SCRs. That money was factored into the net present value analysis that the Commission cites in its decision that says, yes, this is why it's prudent to go forward.
Is that the one where they found a 99.4% chance that you would recover everything plus?
Exactly. And they claim there's evidence in the record that, oh, well, I guess they would say things had changed by August of 2015. There's not a shred of evidence in the record to that fact. No one did that analysis. No one said, oh, that net present value of $300 plus million that was 99% likely to benefit customers, somehow, all these factors had changed, and we've done the analysis over again and proven that as of August 2015, the answer was different. No one did that analysis. No one introduced that evidence. No one claims to have introduced that evidence. That's what you would have needed to prove imprudence and overcome the presumption. None of that is in the record. Judge Morse, I'm not sure. Oh dear, now I've lost I was trying to find the quotation that you were referring to from the 2014 decision, and the only one that I can find refers to deferring for possible later recovery through rates all non-fuel costs of owning and so forth.
Yeah.
That's a quotation from the 2012 decision. That's not, at least again.
Well, but it's in 7486 where they're quoting to the 2012 decision. So they reprinted it in the 2014 decision.
Yes, but yes, Your Honor, but they're just describing what the earlier decision had said, and then in this decision they were completing, they were addressing the question that had been left open in 2012. 2012 left open whether those could be included into the rate base.
Is there anything in there where they specifically said that the SCR was prudent?
No, again, what they specifically say is that what was left open in the 2012 decision, that quotation that you read, right. They resolved that in 2014. They said that is prudent. Our point
so what
is
they were saying is this issue is now ripe. Or
yes.
Your argument is that when they quoted that language, they're saying this issue is now ripe and we're addressing it.
Correct. And they resolved it in favor of prudence. They didn't specifically say, and we find the SCRs prudent, and the reason they didn't say that is because parts of the prudency analysis still had to be done, right? Because you can't make the final determination that it's 100% prudent and incorporated into rate base until the money's been spent and you can analyze, well, did they spend, did they pay the contractor too much? And you can't analyze that until they've paid the contractor. But what they did do, as I've said, is calculate economically, based on the information available as of 2014, it makes sense to spend the money on the SCRs. So as of 2014, we know it made sense.
Is that 2014 decision about the same time they were making the decision for TEP? Or was
no, the TEP decision is 2020, 12? I believe.
What?
2020, I believe.
2020, oh, okay.
Yes.
Sorry.
Yes. And so, again, nothing has been shown to have changed so dramatically from 2014 to 2015 that what made sense in 2014 didn't make sense in 2015, so there's no substantial evidence of imprudence. Counsel made arguments about alleged failure to be forthcoming with the commission, and again, there's not a shred of evidence in the record to support that. The 2014 IRP, the resource planning document, as we've shown in our brief, it explicitly included low gas cost forecasts. The record in front of the agency in 2014, when it was making its prudence determination, included that very same data. The record of that proceeding is part of the public record on the Commission's website. APS's witness in that disputed, contested evidentiary proceeding, Mr. Wild, testified. The 2014 IRP gas price data is what we're relying on for our forecasting, and it was found prudent.
Can you respond to Ruco's counsel's argument about hope and just and reasonable?
Yes, Your Honor. Of course, the process, the fundamental goal of the process is to be fair to both sides. And what the Supreme Court has said in Hope and in Bluefield is, the fairness to the company requires an economic analysis that sets the rate at what the cases say, that is the rate corresponding to rates for companies of investments of similar risk. And they say, counsel argues, oh, well, this was an economic analysis about what other companies with similar customer service could earn. There's not a shred of reasoning to that effect in the Commission's decision. We think that would be impermissible even in that case, but certainly if the Commission were going to say, we're going to do an analysis of companies with similar levels of customer service and conclude what the market demands for investments in those companies, then that would be a different case, but that's not what they did here. I see my time has expired.
Thank you, counsel. We'll take the matter under advisement and issue our decision in due course. With that, court is adjourned.